Thank you, Honorable Speaker. I beg to move that the Privatization Bill, National Assembly Bill number 22 of 2023, be now read a second time. Honorable Speaker, this Privatization Bill 2023 is formulated, Honorable Speaker, as the next generation legal framework that, amongst other things, seeks to overcome the shortcomings and challenges that were associated with the current law, that is a Privatization Act that was enacted in the year 2005. Honorable Speaker, prior to the coming into effect of the Privatization Act of 2005, privatization transactions of the government were guided by the policy paper on public enterprises reforms and privatization of 1998, with the then Permanent Secretary to the Treasury Incorporation Act as the legal framework. In an effort, Honorable Speaker, to enhance transparency in the privatization transactions, the Privatization Act of 2005 was assented to in the year 2005. However, it was not until the year 2008 that this law came into effect. The Act, Honorable Speaker, established the Privatization Commission, whose mandate is to implement privatization. The objectives of the privatization, as envisaged in this Act, Honorable Speaker, are: one, to improve on the infrastructure and delivery of public services by the involvement of private capital and expertise. Two is towards the reduction of the demand for government resources, and also to generate additional government revenues by receiving compensation for privatizations, amongst other objectives. Honorable Speaker, in realization of the objectives of the Privatization Act as enacted in 2005, and as I mentioned, that came into effect in 2008, the principal objectives, as I've stated, of engaging in privatization endeavors by government is: one, to divest, or rather government to divest from commercial enterprises, Honorable Speaker, with the objective of: one, raising resources for government; two, Honorable Speaker, as you have seen with the privatization of many enterprises, government or state-owned enterprises, is to enhance efficiency in the operations of these institutions or organizations, Honorable Speaker, by injecting, one, private capital, Honorable Speaker, where government is limited in terms of the amount of capital that you can inject into state corporations, but also to inject, other than capital, Honorable Speaker, private sector expertise into the running of state-owned enterprises, and therefore enhancing efficiency and delivery of services to the public. And Honorable Speaker, then the most effective of this privatization, Honorable Speaker, came in the privatization of what was then the Kenya Posts and Telecommunications Corporation, KPTC, that was at one time headed, I think, by the Honorable Chepkonga. On one of the offshoots was headed by Honorable Chepkonga, I think, CAK. And Honorable Speaker, the huge investments you have seen in the telecom sector, Honorable Speaker, after the privatization of KPTC, or the Kenya Posts and Telecommunications Corporation, Honorable Speaker, is what led to what now is Safaricom, Honorable Speaker, Telcom, as we know it today. And as I mentioned, Honorable Speaker, the injection of private capital when the investors that came into Safaricom invested in Safaricom. That is how we have seen the country grow in leaps and bounds in terms of the telecoms sector. And you can imagine, Honorable Speaker, had we not privatized this sector, or KPTC as it were then, we would not have benefited from the private sector capital that came through Vodafone and other investors, including members of the public who have invested in Safaricom and other state-owned corporations. And I'm just using Safaricom as an example, Honorable Speaker, being one of our success stories of what has come out of the privatization efforts over the years. Honorable Speaker, however, as it turned out, the Privatization Act of 2005 has been as facilitative for privatization transaction as was, or rather has not been as effective as was contemplated by the Act. and in particular, Honorable Speaker, lengthy privatization processes have required a large layer of approval of decisions at various stages, and this has made the process of privatization very inefficient. In fact, Honorable Speaker, looking at the process in 2008, Honorable Speaker, after coming into effect of the Privatization Act, Honorable Speaker, 28 corporations were listed for privatization. And Honorable Speaker, out of these 28 corporations that were listed for privatization in 2008, in fact, Honorable Speaker, it was 26 entities that were approved by Parliament for privatization in 2008 under the privatization program, as approved then. Only one, Honorable Speaker, and it is 1 out of 26 entities that were listed for privatization. Only the Kenya Wine Agencies Limited has been undertaken. And that, Honorable Speaker, speaks to the issues I'm speaking to of inefficiencies under the 2005 Privatization Act. And Honorable Speaker, it's not just the layer of approvals that were required and the bureaucracies that came with it, Honorable Speaker, but also a litany of court cases, Honorable Speaker, that have bedeviled the privatization process. And Honorable Speaker, protracted court proceedings are amongst these challenges, Honorable Speaker, that have resulted in the slow implementation of privatization. There also have been undue delays in implementation process, as I said, due to the multiple layer of approvals required by various institutions, and also delays in the provision of information during privatization, Honorable Speaker, from the entities themselves. And therefore, this new legal framework under this privatization bill seeks to deal with some of these hurdles and challenges. One, to create efficiencies in the provision of information and even in the formulation of privatization programs, to ensure, Honorable Speaker, that once a program is approved, then the multi-layer approvals, including, Honorable Speaker, approval, and I've just had a discussion with the chair of the committee, because I'm aware the committee had other views in terms of the approval processes by Parliament. And Honorable Speaker, Parliament has a role in a privatization process because these are public entities. And I want to agree with the committee that indeed Parliament must have a role as the people charged with oversight of public resources. Public resources have been deployed in the investments that are state-owned corporations. And therefore, if you are to sell or if you are to privatize these state-owned corporations, then Parliament must have a role in government being able to divest from those entities, Honorable Speaker, to ensure, one, that there is actual and active public participation in these processes as was envisaged by our Constitution. Honorable Speaker, however, the Constitution never envisaged a process where then Parliament also becomes a hindrance to the efficiency of such privatization engagements, Honorable Speaker. And therefore, part of the reasons that, again, Honorable Speaker, that informed this new legal framework under the current Privatization Act, it was required that even the Privatization Commission, which, Honorable Speaker, is not a constitutional commission, ought to have been approved by Parliament. Honorable Speaker, under the 2010 Constitution, because this law was done before the 2010 Constitution, under the 2010 Constitution, it became a prerequisite that only independent constitutional commissions would require the prior approval of Parliament before people taking into office. Honorable Speaker, this new act or this new bill, the privatization bill, bill number 22 of 2023, seeks to address some of those issues. That since the Privatization Commission is not a constitutional commission, then we must not make it mandatory that members of this commission be approved by the National Assembly. However, I am in agreement with the committee that for the privatization program, that then there is a case for the involvement of Parliament because it involves public resources. But for the appointment of commissioners to the commission, that, Honorable Speaker, may not require the approval of Parliament, because in line with the Constitution of 2010, only independent constitutional commissions require the approval of Parliament. Honorable Speaker, this new bill seeks now to succeed, or rather to create a new body, the Privatization Authority. Honorable Speaker, I think they are calling it the Privatization Authority. And this Privatization Authority, Honorable Speaker, will be the successor of the Privatization Commission. And this authority, Honorable Speaker, again, the proposal was that this being just an authority and will be governed by a board, that board does not necessarily, just like all other boards to state entities, they never require parliamentary approval. And I think we have had consultations with the chair and the committee that we do agree with what is provided for in the bill, that the board then can be set up without necessarily coming to the National Assembly or to Parliament for approval. However, Parliament has a role in oversighting that board in their dealings in matters to do with privatization. And again, Honorable Speaker, as I have stated, that is where I want to agree with the committee that when it comes to the privatization program, then Parliament ought to have a role. Honorable Speaker, this authority, once established, will have certain functions, and amongst some of the functions of this authority will include advising the government on all aspects of privatization of public entities. It will also be facilitating the implementation of the government policies on privatization and implementing specific privatization proposals in accordance with the privatization program. Honorable Speaker, Part 2 of this bill is what members will see provides for the function of this board, and also the function of the Cabinet Secretary, which will include providing policy direction on matters related to privatization and developing and formulating the privatization program, which, Honorable Speaker, I'm saying that is where now, as we go into the third reading or committee of the whole, Honorable Speaker, we should look at how we can then get Parliament or the people's representatives being involved, either in the approval of the privatization program or the policies as the CS will formulate. This part of Part 2 of the bill, Honorable Speaker, also provides for the appointment and functions of Managing Director, the Corporation Secretary, and staff of the authority. Part 3 of the bill, Honorable Speaker, deals with the privatization program. And if you go to clause 18, Honorable Speaker, of the bill, it provides that a privatization program shall be formulated by the Cabinet Secretary in accordance with the Acts, that is the Privatization Act, and approved by Cabinet. It will specify the public entities identified and approved for privatization and serve as a basis upon which the privatization shall be undertaken. This part also, Honorable Speaker, makes provisions for the formulation of the program, which includes identification of entities to be included in the privatization program in line with the considerations, public consultations during development and notification of, by Parliament before implementation of the program. It further specifies the validity period of the program as not exceeding 5 years from the date of gazettement, and such validity may only be extended for a further 12 months or a further 1 year. Therefore, such a program, Honorable Speaker, in line with this part, means that a privatization program can only run to a maximum of 6 years. Honorable Speaker, you can imagine the privatization program of 2008 of those 26 state corporations, as I've mentioned, only QUAL, or the Kenya Wines Agencies, has been successful, and the program has been in existence from 2008. We are now in the year 2023, that is 15 years later. We are now putting a time limit under this new act that such a privatization program can only run for 5 years. And if within 5 years you have government has not finished that program, they can only seek a further extension of only 12 months to be able to conclude that program. So that again, Honorable Speaker, we ensure that there is efficiency in the privatization of state-owned entities. Honorable Speaker, there is a reason as to why there is a time limit, Honorable Speaker. And this is informed by the fact that for you to be able to derive actual value from state entities that you want to privatize, then time is of essence, Honorable Speaker. Not just in terms of the time value of money, but also, Honorable Speaker, you can imagine there are entities or state-owned entities whose value today will not be the same 15 years down the line. And therefore, there are state entities that government envisaged to privatize 15 years ago, and we have derived very good value out of those state entities. But because of advancement in technology and changes in the global economy, some of those state entities have now become moribund, and even the technologies they are applying, Honorable Speaker, are not technologies, Honorable Speaker, that would derive value in today's world. And therefore, the Kenyan people or the public will not derive the true value of an entity if the process is so protracted and runs for 15 years, as was happening under the old Privatization Act. Therefore, Honorable Speaker, under this new privatization bill, we will seek to ensure that there are timelines, strict timelines, under which to implement a privatization program. So that if you are privatizing, for instance, a technology-based company, you do not take 5, 6, 7, 8, 10 years, and by the time you are seeking to privatize, the value of that company has dropped to almost negligible figures, and therefore the public loses value. The intent of this bill, Honorable Speaker, if it becomes an act, Honorable Speaker, is to ensure that we derive value at the right time, when we can derive the maximum value out of the state-owned enterprises that we seek to privatize. And I do hope, Honorable Speaker, that members will support this bill to ensure that we never lose value. Honorable Speaker, you have seen how the Honorable Waue has been active in pushing through the sugar bill. You can imagine, Honorable Speaker, if, for instance, the sugar companies in the Western Kenya belt and parts of the coast were privatized, say 10, 15 years ago, the value would have derived out of those sugar companies, that some that we have been just talking about their privatization, but it has never happened. And I want to pray, Honorable Speaker, that this time round we shall get it right. So that, Honorable Speaker, we do not punish another generation. We have wasted 15 years trying to privatize state-owned entities. Some, Honorable Speaker, if you visit some of those state-owned entities that were earmarked for privatization, they are basically dead, Honorable Speaker. Some today, if you were to privatize them today, you would sell them for a song or for no value, Honorable Speaker. But had we done it at the right time, Honorable Speaker, we would have derived value for the public. Those entities would have become more efficient. We would have been able to deploy private capital, therefore enhancing efficiency in the operations of those entities. We'd have been able to deploy private expertise or expertise from the private sector. Honorable Speaker, I mentioned the sugar industry because it is one such case. Well, Honorable Speaker, whether you go to Mumias, whether you go to Nzoia, whether it is Sony Sugar, Honorable Speaker, you'll be shocked that the kind of equipment that is in those sugar companies, Honorable Speaker, are so moribund and inefficient that it becomes so expensive to run those entities. And that is the reason why you will see the people of Mumias, every successive administration from the Kibaki administration to the Kenyatta administration, now with the exception of the Ruto administration, has pumped money into Mumias. But what have we derived out of the money that we have pumped into Mumias, Honorable Speaker? Absolutely nothing. So we have wasted a lot of public resources pumping into inefficient entities, Honorable Speaker, and that is what is informing this privatization bill, that we will enhance the efficiency with which we privatize state-owned entities, so that we deploy private capital, private expertise, private technology from the private sector, Honorable Speaker. If we had deployed private expertise in Mumias, Honorable Speaker, the cartels that have been running the sugar sector in Kenya would have been driven out of business years ago. And I must take this opportunity, Honorable Speaker, to commend His Excellency the President. Because he has said, and he has told these cartels that there are only 3 things to do in this country. And in those words, Honorable Speaker, if I may quote him, he has said, Mambo ni Matatu. And in this Mambo ni Matatu, Honorable Speaker, because we have been speaking about the fight against corruption, Honorable Speaker. And I say speaking, Honorable Speaker, because all we have done in this country is to speak about the fight against corruption. Nobody has been bold enough to act on issues corruption. I must commend the President because he has indeed shown the country that with the Mambo ni Matatu, he intends to act on corruption, not to speak about corruption. Honorable Speaker, you remember in the last regime, at one point during a State of the Nation address, the former president, speaking about corruption, fired over 200 public officers, many of whom ended up getting back into public service because we are all accustomed to speaking about corruption. Honorable Speaker.
Honorable Kajwang, what's out of order?
Madam Speaker, the majority leader is referring to what we have had out there as Mambo Matatu. Mambo ni Matatu. Can majority leader confirm that he is encouraging extrajudicial killing or